Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property brought to you by the Chartered Institute of Patent Attorneys.
Hey Gwilym, how are you? This fine day. It was snowing this morning.
I've just walked miles. I'm damp.
In the snow or just in the rain?
No, it's warmed up, so it's wet. It's just wet snow, aka rain.
Yeah, no, I came into Waterloo this morning so excited because there were really, really thick flurries of snow. And then you lose that excitement, don't you, when it just turns to mush on your coat and
Yeah.
And I thought about jumping on a bus. I jumped on a bus last week and it took a ridiculous amount of time to get out of the office. But I thought, it'd be a little bit drier and warmer. But the queue was horrifically long. And I thought, why are all those people standing there to get on a bus that's going to take them much longer to get to where they want to go than it would walking? And they're getting wet anyway.
They should get a consultant in.
Yeah. Do you want a little bit of news on the SEPA front?
Ooh, yes.
So do you know we've been supported ably over the last couple of years by Ria, who always lurks in the background on these calls and does the recording for us and does a big chunk of the editing and all of those kinds of things?
Yes.
This is her last week. This is her last podcast.
No, it cannot be.
She's off to Pastors New. She's off to another membership association. She's leaving me, Gwilym. She's leaving me.
She's listening. Ria, we know you're there. We know what you did.
I don't think we're going to be able to coax her on. Not at the start, anyway. Maybe we can get her on towards the end. But I think we should say a big thank you from the podcast. I mean, we'll obviously say a thank you for all of the work that Ria's done for SEPA over the years. But I think we should just say a big thank you from the podcast for Ria for supporting us.
Actually, yeah, we should. Well, absolutely. And we've got all these other people we never say thank you to. We should say thank you to.
Oh, the people in the background. Well, Neil comes on occasionally, doesn't he? Neil will sub for me or you if we're not around.
Yeah.
We've got Emily and Apina and Fran, who Fran, of course, started off the podcast really in terms of working out the tech for us and doing the editing. But yeah, Emily and Apina and Fran in the background doing all of the editing and making us sound like we know what we're talking about, which is no mean feat.
No mean feat. They're all great. Thank you, everybody.
Yeah, no, thanks to everyone, really. Yeah, but yeah, sorry to see Ria go, but hopefully she'll find an amazing new role that she's moving into. So that's cool.
It shouldn't get to do a podcast.
No, I bet she doesn't. Yeah, I bet there's no talent there. Be no talent. So speaking of talent, should we get the guest on?
Yeah.
So occasionally we have returning guests, which is for a couple of reasons, isn't it? So it'll either be because they were so amazing last time that we feel that we need to revisit them and the subject, or that we've just forgotten we've had them on before. So and I don't know which it is with Ryan. Ryan, who are you? Tell us a little bit about yourself.
This is after the two of you were just telling me how amazing I looked and was. And Gwilym named his recent child after me. So I assumed it was amazingness, but and I was here for the kind of final Ria podcast. So I took that as a great mark of honor, but could also be that we just all have short memories.
It was a long time ago that we were last together on the podcast. It was May of 21, which was kind of deep, dark pandemic days.
Right, it all blurs together.
Yeah, I had a little listen back earlier, and we certainly started off talking about the fact that we may never see the real world again, and where we confined to our houses for the duration. Turns out, a couple of years, and we were good.
Yeah, now you can go back to getting wet waiting in a queue.
Yeah.
Podcasts are a really good historical document for that, actually, because they're recorded conversations about what was happening. I listened to a whole series of a rudely named one, but I listened to a huge long series, and it started off in the depths of lockdown, and it was really interesting listening back at some of the conversations. It's a good historical document.
I think so many started then, didn't they?
Yeah.
Anyway, Ryan, can you introduce yourself for the listeners? Because we know who you are. They don't unless they listen to the last podcast, which is unlikely.
Yes. Well, I'm Ryan Abbott. I'm professor of law and health sciences at the University of Surrey School of Law and a attorney partner at Brown, Harry, Smith & Kahn in the United States and a mediator and arbitrator with JAMS. And I assume that I'm here for my infamy associated with the Thaler or Davis cases. Or just because Gwilym thinks I'm very handsome.
You're looking great, but you're also, that your knowledge on all that stuff is also super interesting. And I think we have some updates, things happening, what's going on, all that.
Yeah, so do you want to give us a potted history of the project? And I know we did it in depth in the last podcast, but let's start off with at least reminding people about the project. And I know since we last spoke, it's been tested in a number of jurisdictions with different outcomes.
Indeed. Well, I'll give the slightly longer rambling version, and you can interrupt me when it becomes even less interesting. But we go back about 10 years in time, and I was working as a baby attorney in the life sciences and noticing in drug discovery that people seem to be doing some interesting things with AI. And some vendors, kind of the forerunners to AI-generated drug discovery, whatever that is, were advertising that they could do things like if we gave them a therapeutic target, they'd have a computer go through a big antibody library and pick the antibody out that would be best for us. And this could be our lead drug candidate. This is a company I was working for. And we could file a patent on that. And that's the foundation of a new drug portfolio. And I thought, well, that's interesting because it sounds like an AI is automating, at least some of what traditionally makes a human being an inventor. And what would happen if you had an AI invent something? And it turned out people had been thinking about this for a long time. People have been writing about it since at least the 60s. And academically saying, because at the time only academics took an interest in this, you really wouldn't need a patent because an AI doesn't care about getting a patent, and patents are to, incentivize inventors. And I thought, well, that's not quite right, because really all of these inventors assign their patents to the pharmaceutical company anyway. It's the companies that need the patents to hire the inventors and to invest in doing clinical trials and to disclose these things. So you need a patent just as much. And why wouldn't you want companies using AI and R&D if you could get it to do a better job than a person at something, which it wasn't really doing then, although it's all very complicated. But I wrote some law review articles on it, and for the first time, people took an interest in things I was writing. And in a couple of years, it had gone from this is vaguely academically interesting to, we're kind of concerned about this. We pay you a bunch of money to help us think it through. And at some point, one of my colleagues said, well, why, if this is an issue, aren't there any cases on it? And I said, well, you'd have to really proactively disclose you had an AI do this. There's a huge incentive not to. And, otherwise only in litigation in the US, but that's probably going to take a long time. So I, assembled a group of patent attorneys to file a couple of test cases for AI generated inventions. I spoke to Dr. Thaler, who I had interviewed for the academic work, and said, would you be interested in having your AI system generate a couple of inventions or an invention? And he and others had done this previously, again, kind of as proof of concept experiments. So he had an AI generate 2 inventions while he was at it. We filed applications on those at the UK IPO, just to, help the British patent attorney milieu. We did this because they did a substantive exam before looking at inventorship. The patents both passed preliminary substantive exam. We filed a Form 7 and a PCT application and said, well, actually, these were invented by an AI, and the person who owns them is the owner of the AI on the principle that you own property made by your property. And then we filed it in 17 places, and some interesting things happened. I could continue to ramble.
No, you carry on rambling. Rambling's good at the moment.
Ramble away. So in 2021, although again, it does all blur together, South Africa granted us a patent with the AI listed as the inventor, which again, isn't a matter of giving an AI rights. Most inventors don't have rights to their patents, although all of this is very complicated. Plus, an AI is not a legal person that couldn't own property, but it is to be transparent about how an invention is made. And with the AI's owner is the owner of the patent. South Africa doesn't do substantive examination, but these have already been substantively examined, and they do formalities examination. So we got a patent there. And later that week, the enlightened Justice Beach in the Federal Court of Australia issued a 40-something page reasoned decision about why under the Australian Patent Act an AI could be an inventor, and why at least we had made the best showing of entitlement to that patent. That got overturned at an en banc decision. The Federal Circuit in the US rejected the application on the basis that an inventor is defined as an individual in the Patent Act, which the Supreme Court has held usually means a natural person. We pointed out usually. They said, well, the dictionary says an individual is a person. And we pointed out, well, the very next sentence says an individual could be a thing. So that doesn't really work. But there you have that. And they said, well, if you look through the Patent Act, it seems to assume an inventor is a natural person. And we said, well, the US patent law has this unique provision, or provision anyway, that you can't negate patentability on how something was made, which is what they were effectively doing. And they said, well, for the first time, we're going to say this applies only to non-obviousness. As a result of that decision, and the Supreme Court didn't take the case, the US Patent and Trademark Office amended their guidance from AI, nothing to see here in 2019, to a human being has to make a significant contribution to each claim in an invention where the claim is unpatentable, and potentially the entire patent. Inventorship is uniquely important in the US as a substantive thing, which we can come back to talk about. So we have one model there. It went up to the UK Supreme Court, which I got to argue, which was great fun. And Americans just asked if I got to wear a wig. I didn't, which was unfortunate, but you'll know that. I thought we had a pretty good chance under UK patent law, which basically said the inventor is an actual deviser, which is agnostic to entity nature, and that you have to disclose all individual inventors who are natural persons. And we simply submitted that the designation was no one. We could talk more about that case that we lost, although the case is now back at the High Court. Just a couple months ago, though, we won in Germany at the highest civil court, which resolved a circuit split between two appellate German courts, one that held these inventions are inherently unpatentable, one that said they are patentable. And the German Supreme Court said all you have to do under German law is have a person cause an invention to be made, and that is sufficient for inventorship. So on our facts, we had that. So you now have a lack of harmonization about this, although inventorship law is already pretty disharmonized. In Austria and Israel, for example, you don't have to disclose an inventor. And Cyprus and Monaco, which are EPO member states, they've reported to EPO that they allow corporations to be inventors. And then in most other jurisdictions, the cases kind of very slowly trudge on. That was a pretty good sized ramble. Lee, you look like you're checking your email.
No, not me. Not guilty. I was actually just dropping Gwilym a little message in the chat.
It's been a roller coaster, that's for sure. Because I think when we last spoke was before the Supreme Court, a long time before the Supreme Court, wasn't it? Things were more up in the air. But I think around then, perhaps there were some reversals going on. It's interesting because I have to say, after the Supreme Court decision, I'm afraid to say, Ryan, I thought that the story might be coming to an end, but it clearly isn't. That's great news. It's great news because it's creating a huge debate about something we're going to have to face up to in due course.
Yeah, that was a big, that was one of the three reasons we did this, because this wasn't really on people's radars, or if it was, they weren't talking about it. The law historically kind of lags behind technology to the point where you have problems about this. As, for example, right now with, copyright training issues with machine learning, which is just a hot mess in different places, especially the United States. And I would submit more or less a disaster because no one seems to have seriously thought about this, before it came up. So, part of the goal was that you not have pharma companies losing patents left and right, at least in the United States over this in a decade, and that instead you at least have guidance for stakeholders. And I think the product has been very successful in doing that. It's been named, explicitly in all these consultations that AI and IP offices are doing. And people have different normative views or statutory views on what the solution should be, but it is, I think, for the best that we're not thinking about it for the first time once we have kind of widely available inventive AI generating socially useful stuff.
So you mentioned there, Ryan, about the way that technology runs ahead of the law. Is there a danger that the market ultimately decides and actually this renders the whole system pointless?
Well, that sounds very European in the framing of it, right? The idea that the market would decide would horrify our EU colleagues who just passed the EU AI Act, whereas, the American colleagues tend to think that's probably the right solution. I mean, there are, to be sure, a lot of regulatory forces on how AI is used and developed, the market, soft regulation, EU regulations, US regulations, technological constraints on things, all of these have an important role to play, and IP law generally is a government intervention on a market that we don't believe functions well enough without a government monopoly, a state sanctioned monopoly, right? We think we won't have enough of the right sort of activity if we don't have patent law. And therefore we have patents, which are, by their very nature, as anti-competitive a tool as you can get. So, again, and then this kind of goes back to what do we want for a system? What do we think the benefits and the costs of having patents are, which aren't necessarily the same for every jurisdiction. Some jurisdictions like the UK are big IP exporters, some are big IP importers. AI is maybe changing this in interesting sorts of ways. On the copyright front, I realize the audience probably doesn't care about copyright so much, but it is very interesting to leverage for these discussions. People were historically, when I was writing about this before the widespread use of LLMs, like ChatGPT a couple of years ago, when AI making art was something that generally academics and a few artists were interested in. But academics thought, oh, this is going to be awful when you have, Google Gemini, Google's going to own all the art in the world, right? Whereas instead what has happened is, they've been platform companies that are, if anything, democratizing the ability to be creative in a way that, people other than music and movie studios didn't have before. And so now I can ask Google Gemini to make a creative image and it will be a pretty good one now, I usually find. Right. And so this is allowing people in jurisdictions that aren't the UK to leverage these technologies in ways that people, I don't think expected would happen.
That's a long answer, Lee. I'm going to dig out a little bit of that, though, which is actually quite a kind of broader picture thing, is that I think you're saying in there somewhere that you can't just let the market decide some stuff because it makes some really bad decisions. And that's when the government steps in. And so this might be one of the areas where the market now might not like it, but the market needs to be looking a bit further forward, kind of thing.
Yeah, I think that's kind of generally a defense of regulatory activity, and different regulators take different views on whether a market-based or a state-based framework tends to be more appropriate. But patents are, again, by their nature, entirely a state-based, mechanism, now subject to kind of global norms through TRIPS, among other things. But, and so, companies have now in the past 5 years tended to take positions on protection of AI generated content, and are actively lobbying lawmakers around the world for their preferred solution. And by and large, most of the attention has focused on copyright. And I think that this is because it's now easy for everyone to see AI generating creative stuff. It's also a lot easier to make something creative than something inventive. And kind of AI in the creative industry has, blossomed as a giant social concern. For example, a motivating factor behind the writer's strikes of last year. So a lot of the lobbying is on things that are kind of very pressing right now, like training, deep fakes, to a lesser extent, ownership of AI generated content. The patent stuff remains, I think, niche for industrial engineering and life sciences, where, many companies claim to be making AI generated drugs. And there's a vision that AI is going to totally change the way drugs are discovered and used. That vision hasn't come to fruition yet, but people are putting large sums of money into it.
So, just closing off kind of the Davos story, then you mentioned it's reappeared in the High Court in the UK. What's happening?
Well, a couple of interesting things are happening. I refuse to give up as a matter of course, generally, right? So that's part of it. Most people would just sort of take the Supreme Court case and be done with it, but no, we're not. We don't roll that way. A couple of interesting things happened at the initial hearing officer said, look, UK patent law doesn't protect this. It's all very interesting, but given what you've told us about how the invention was made, I can't see how you could get a patent from us, right? And a fair position for them to take. But then before the Supreme Court, they said, we could care less what's on this form as long as it appears to be a human being. We won't look behind it. And if you'd only put Dr. Thaler's name, whether it was because he used or owned the AI or he didn't really have to have any involvement in it, that would have been fine for us. So that was a submission they made in oral arguments. And so we amended Form 7 and said, okay, well, if that's your position, here's a new form. And they said, well, not in light of the new Supreme Court jurisprudence. So we are, our case deliberately took the factual position that, the AI was the actual deviser of the invention, as it did the thing that would traditionally make a human being an inventor. Now, what that thing is, varies by jurisdiction quite substantially. So, an example in Germany, it can be, I pushed a button. In the US, it has to have been a significant contribution to a claim, has to be conception versus reduction to practice. In the UK, what does it mean to be an actual deviser exactly? And what does a person have to do versus a machine? And where is the line at which something becomes unpatentable? Now, I think that will kind of be the next, subject of cases, although patent attorneys take different views on this. Well, it is certainly less important in the UK because there's limited grounds to challenge inventorship or entitlement. You have to be yourself an entitled party. And if you don't, the general view seems to be that if I put my name on this thing and then sued you for infringing it, you couldn't challenge that I wasn't appropriately entitled to it. But, some attorneys do think there is some equitable remedy out there somewhere for this. In the US, it is something someone can challenge in an infringement proceeding at any point, and it can render a patent invalid or unenforceable. And so, this is commonly tested in litigation, and when you depose a pharmaceutical researcher who's a listed inventor and she says, well, I use this platform from this company and no, I don't know how it works, but I asked it to generate a new drug and it did. And it said it made 1 million of them and this, had all kind of the traditional criteria we look for. And I don't know how it predicted that. And, it just told me this was the best drug. So I gave it to our patent attorneys and they filed it. You would now lose this patent in the United States. But anyway, so back to the High Court. So that's thing one. So we are, trying to explore where these lines lay, and arguing, fundamentally, if the UK IPO wants to take the position that it doesn't care, it's none of its business, that's fine, but then it should grant us this patent. And then there is a procedural issue that only a patent attorney could love, which is whether a divisional filed while the applications were live, but after they were eventually deemed withdrawn, is a valid divisional based on the timing of that.
Let's not do that one today. Can I go back to your point about the UK in particular, that we're not that bothered about inventorship in the sense that, as you said, there's limited opportunities to challenge it. And that was Burse's position, wasn't it, at the appeal level, is that the 1977 Act was kind of designed to remove the debate about inventorship unless the inventor themselves had a problem with it. And so I think my understanding of part of his point was that, no one's challenging it. You said it was who it was. You believed it. Everything's okay. CEPA liked that argument. We actually put a submission into the Supreme Court, as kind of supporting that line of thinking. Obviously, it didn't come through, but do you think that's the direction that the legislation should go? Is just keep away from the American prevalence of the inventor, as it were, and to kind of keep it between anyone who thinks there might be an inventor and leave everyone else out of it?
Yeah, it's a good question. It is clearly a broader point than one related to AI-generated inventions. That is, and I think it was actually, I just got back from China and the AI PPI, and that was one of the study questions there on harmonization of disclosure requirements and this sort of thing. Most jurisdictions don't really care about inventorship. It generally just matters to entitlement, and very few people can challenge it. Burse's point was that, and also that the UK IPO shouldn't be in the business of verifying these forms. The form was filed. Their job is to process the form. There was a bona fide belief that the form was accurate anyway, but really none of that's UK IPO's business. We don't have a concept of fraud on the patent office here the way that we do in the States. And I think Burse was kind of looking over at America and seeing everyone suing everyone else about everything and thinking we probably don't want that here in the UK. That's probably right. I think it probably is right. The other components of this kind of issue and question being, what rule do we want to have for this sort of thing? And the UK is kind of interesting, just again to bring copyright into it. they were the first jurisdiction anywhere in 1988 to explicitly change copyright law to say, when you have a traditionally authorless work, we're going to provide protection for a computer generated work under this special scheme.
Mhm.
And I did think that that was particularly forward looking and future proofing. And granted, people in the 80s apparently thought this needed urgent answering, and they were 35 years ahead of their time. But on the AI generated issue, it would be nice for Parliament to kind of step in and say, this is what we want, and we want it for good policy reasons, and here's the law on it. But I do think also that, the Patent Act as it is did have an answer in that, particularly if you looked at it purposively rather than kind of a literalist approach to the question.
So this become, can I call this a passion? Is this a passion, this whole AI thing for you, Ryan?
Yeah. It sounds a little odd if I'm passionate about AI, which sounds like I have an AI girlfriend, but I don't.
I wasn't fishing for that. That's good to know. I was going to talk about, are we still plugging your book?
Oh, please. I have a couple new books, but yeah, plug The Reasonable Robot.
Reasonable Robot is a really, really good read, everybody listening. But also, I think it's one of the early kind of full discussions about what happens when we start accepting AI as almost as a person. And obviously, the book took it beyond IP significantly into, I know definitely car insurance was an interesting topic and various other things as well, but really interesting. But it feels like that debate has become more mainstream now. There are more discussions about what if. And then I saw in the US, there's one at the moment, the USPTO has got a consultation out about AI and the risk of AI creating loads of prior art. Is this familiar?
Yes, it is. You picked up two veins there, but I will remember to Venmo you something for plugging The Reasonable Robot. And historically, you've had a copy of it to wave around or hit Lee with, but I'm sure it's there somewhere. It is not transferred. Yeah, that clearly is it. Right. So, IP agencies and regulators have been thinking about AI and IP for a long time. And again, it's always been kind of very academic, largely, the UK being a notable example of different of that in copyright. But the USPTO kind of set a new wave of this off in 2019, where they released 2 requests for comments, and the summary of which was not much to see here. And then kind of a lot of other people got in the mix, like UK IPO. They've recently done a 180 on this, as I mentioned, and now they're thinking of all the other interesting ways that AI is going to change IP law and digging into a couple of these. And there really are a lot of them, with how, the book broadly dealt with the phenomenon of AI behaving like a person and how the law deals with that, whether it's inventing or creating something or setting standards for human behavior like reasonableness, including in the self-driving car field. But we have kind of reasonableness standards in patent law with the person having ordinary skill in the art. And as you have an AI that starts automating routine R&D activities, how does that change standards? You either have an AI represent the person having ordinary skill in the art, or the person having ordinary skill in the art is a human researcher using a generative AI system. And, semantically, those are different, but functionally not so much. Other, questions include, you can have an AI make a huge amount of stuff. Is that prior art, and is that a problem? And in the US, prior art has to be enabled. So we've had a company, for example, All Prior Art, that's been working on having an AI make every conceivable sentence for many years. A claim has to be one sentence in the US. So, if in a database of a quadrillion sentences, you have an identical, passage, or claim, is that prior art? Is it enabled? Is it accessible? One of the really interesting areas that I don't work in so much, but is AI making design patents or registered designs, because AI is really good at spitting out variations on industrial designs. And those applications are just drawings. So, is AI preempting whole fields of activity? And is that a good or a bad thing? And do we want lawmakers to carve out that sort of stuff? My own view on this was, you don't want a two-track system for AI and people. If you have AI making useful prior art, that is something that should be considered prior art. It would be very difficult to deal with otherwise, all the incentives to move the right place. But that if you do have this gigantic database no one could possibly use and has no value and just has sentences, that isn't enabled prior art.
Yeah, I mean, it's also weird. Why would somebody use AI to create loads of prior art? It's just an odd concept. They could hope to monetize it or something.
Well, for a few things. I mean, one is people do deliberately poison the well as a research strategy. So if you aren't planning to patent in a space that you're active in, you might want to release prior art to keep other people from patenting in the space, right? If you don't want to, enforce patents, some people, have a view of patents as inherently bad and kind of academically want to blanket spaces with publications to prevent, monopolies growing up in the space. Those are kind of two of the big reasons, I think.
Yeah, it just interests me that it never occurred to me that it would be something that needed legislation, but it clearly.
Gwilym, can I chuck one in that that I usually ask the daft question, so let me ask a daft question. So we've been doing quite a lot of work, both on the podcast and in conversations around non-practicing entities, so your patent troll type arrangement. Could AI, if AI gets widespread inventorship, could you foresee a future where AI is used in that kind of like aggressive way to just flood the market with patents just for the purposes of litigation?
Although there's a lot to unpack in that quote unquote daft question. And I don't think it was terribly daft. And I have been sticking pretty patent attorney-ish, but I assume that is your target market here. And we're not, too much hitting up the sixth form listeners. I do have a daughter in sixth form who's not listening to this, or I'm sure will not listen to this. So there's a kind of different views on whether non-practicing entities or, the derogative term patent trolls are a good or a bad thing for the patent system and whether, right. So there's all that too. Right. But, yes, this gets to kind of the concern, which I kind of mentioned in the copyright space, that let's say you get, AI isn't that great yet, but we've seen how very quickly it improves in creative stuff. Let's say in 5 or 10 years, you really do have an AI where you can say, I'd like a drug to treat this or optimize this design. And it just does it, and it does it extremely well. And it is really prolific at doing that sort of thing. And yes, you would be able to get lots and lots of patents on that activity. Now, I tend to think that's a good thing because, let's say you were able to take a sample of someone's cancer and run it through an AI, and the AI can make a personalized antibody to treat your cancer, right? You could monopolize the field for treating cancer. On the other hand, that means we've now got the cure for cancer. So if AI is spitting out all this really useful stuff at volume, that just means we're getting what the system was intended to do, socially valuable stuff. And, there is a 20-year kind of limit on how much protection someone can have. And after that, then we all have free access to the cure for cancer in a way that we didn't previously. Someone could, do some, bad stuff with that. If you had the cure for cancer, only let someone have it in return for $1 billion, per person. There are safeguards built into patent law, like compulsory licenses to deal with that sort of thing. But also, again, what we saw in the copyright was a little bit less, one company's going to control the stuff and more platform companies are making this available, so that you could potentially use AI to make something inventive. But, we will see how it washes out. But yes, as you say, there is a concern. Someone could try and really dominate certain scientific areas with these technologies.
I'm going to just touch on something that has been one of the big themes is this, as you say, AI just treated like it's a person, but also AI as the skilled person, which it begins to introduce a whole bunch of interesting patenty things. For the non-patent specialists, the skilled person is the nominal, non-inventive, but knowledgeable person to whom who never has an inventive thought, who knows how to follow the instructions in a patent document to make it work, and various other kind of tests all sit around this nominal skilled person. And Ryan, I know you had a good think about what it means. If AI becomes a skilled person, or if that becomes the test, then that causes all kinds of problems later on, because everyone else is basically a bit not a genius. An example being, go back to the pharmaceuticals, that so if you suddenly say, well, just because AI did it, there's no inventive in there. It just messes things up. Is this debate still going on about that conflation?
Oh, yes. I will remark, you seem to look right up at me when you said a person who's never had an inventive thought, but well, messes it up or fixes things, right? So, we have this bar in patent law, which is we don't want to give a patent for something that, an average researcher would have come up in the ordinary course of things with, because, economically speaking, we didn't really need that incentive for that invention to come about, right? We only want to reward extraordinary effort, something that we think wouldn't have been invented but for a patent incentive, or at least the patent incentive significantly sped up the introduction of this invention to society in a trade-off we find worthwhile. Now, let's fast forward 10 or 20 years and assume that we have AI that is really vastly more capable than human beings in certain areas, like drug discovery, like you have a disease and you just ask an AI to make a treatment for it, and it does. That then becomes routine activity that you don't need a patent to incentivize. And so it probably isn't something that we want to grant a patent for. It's something that really anyone could have done, or any average researcher. Now, in this hypothetical future in which AI is outperforming people, yes, it becomes very difficult for an unaided natural person to make an inventive thing, but again, otherwise you basically have a protectionist system where we are rewarding certain kinds of human effort, even though we could have had an AI do it kind of very cheaply and quickly, just to encourage someone to be an inventor. And I don't think protectionism has really ever been the route to go when dealing with technology. I don't remember if I used this metaphor on the last podcast, so I'll use it again. Well, not metaphor, but example. I was in Brazil some years ago, and they had elevator attendants in all of the commercial buildings. And I asked why that was, and they said, well, it was, a union thing to give people jobs. And, that did give people jobs, but it wasn't a very productive use of their labor. We could have had elevator panels and they could have been out doing something more productive. And, as people are struggling with this very much so in the creative industry right now, I don't think the solution is like you have special incentives for people or you ban the use of AI. AI will replace certain jobs. It will make other jobs. We should have policies that help people who've been rendered technologically unemployed with more benefits and retraining. But that is what produces more benefits for everyone. And if we get to this hypothetical future in which AI can really do everything a person could do much better, then we could have an unlimited amount of wealth and leisure as a society. And the goal there is to just keep all of the benefits from flowing to Elon Musk and Sam Altman and making sure that we get some of them. Speaking of your kind of future question about, AI doing things in the future, Sam Altman and Elon Musk say a lot of things, but they also think we're going to have AI that's broadly at the intellectual capabilities of a human being in a couple of years. And if they're right about that, that really is a pretty disruptive social concept, but also for patent law.
So Ryan, one of my jobs on the podcast is to kind of keep an eye on the clock. And you'll either be delighted or terribly frustrated. Though we're going for 45 minutes now. I've got at least one other question. I don't know whether Gwilym's totally exhausted. Are you exhausted, or shall I? Because mine is a bit of like taking us towards the end question. I don't want to take us there if you've got more to ask, Gwilym.
I was going to ask the question about plumbing, but I guess we can do that after the podcast at the pub.
No, go for it, Lee.
So you were talking kind of like end game there in terms of human level artificial intelligence and what that might mean generally as like a social construct. But what's end game for you, Ryan? How long do you keep this going? Is end game that there ends up being some kind of international harmonization around AI as an inventor? When do you step off the roundabout?
Yeah, no, I think I'm on the roundabout for a good while, which is nice because it means I don't have to think up anything new. This is really the case that just keeps on paying dividends. And I just keep writing the same law review over and over and giving the same talk over and over. And this is really sort of the academic stream. But when I first spoke to reporters about this in 2019, when everyone thought this was a ridiculous publicity stunt, and I no longer get that too much. The reporters are like, "So when will this all be done? 6 weeks?" And I'm like, probably at least 10 years. And they seemed unable to accept that as an answer. But here we are 5 years in. And I think we started kind of the work in 2018. So we're at least halfway through. I mean, look, jurisdictions have to decide for themselves what they want their rules to be. I think this case law has really helped stakeholders. It's promoted discussion. It's advanced one view of how things might want to be. It goes now from courts to policymakers to kind of have public debates and discussions about this. And then ultimately, yes, the ideal would be that you do want some sort of international harmonization, because it shouldn't matter if you're using AI to make an inventive thing in the UK or the US or China or wherever you are. An invention's an invention. And so, hopefully at some point in the next 30 years, we'll get something like that. And in the meantime, I get to keep appearing on podcasts.
30 years. Gwilym, have you got another 30 years in you, mate?
Oh, yeah. I'm nothing stopping me.
I'll be nearly 90. No, that's kind of not happening. I won't be here. So I think we're done or thereabouts, except I know that Gwilym's sitting on a question that you're desperate to ask, aren't you?
I am. I've just realised we've got our closer. I'm going to have our closing question. Ask Lee first, then you, Ryan. I've got one today, but I wouldn't be surprised if it's the same one we did last time. It doesn't matter because that was 2020.
Is it the? I can't remember what we did last time, so my answer won't be consistent.
But it's okay, because then we can basically compare our answers, which are probably going to be different. It's very simple.
It's always 42, by the way, Lee.
That's deep thought. Now that's an AI. That was. So first of all, we've talked lots and lots about AI becoming, treated like a person and replacing the skilled person and all these other things. Driving cars. We talked about that, but you read the Reasonable Robots. Very interesting. Oh yeah, what are your other two? What are your other books, Ryan? That's what I wanted to ask before I get to my closer. Sorry.
Oh, the research handbook on AI and IP by Edward Elgar, and the International Intellectual Property in a World Integrated Economy by Aspen Publishers. So those books are even more riveting than The Reasonable Robot, one of which is a research handbook and one of which is a textbook. But I'm now working on an encyclopedia of AI and law. So that's going to be the most page-turning yet.
Really cool name. Reasonable Robot is you got to read that. Anyway, closing question. AI, Lee, what job that you do would you most like AI to do instead?
Oh, I guess the obvious answer is none, because I quite like working I don't like working for a living. That's not true. I quite like getting paid, which is slightly different, isn't it?
You don't want money, do you?
I love my job. I love it. I love working with people like you, Gwilym. So it's probably I don't know whether AI would be able to do that. I'm not the world's greatest networker. I hate being stuck in a room with a load of people I don't know and being forced to make kind of polite conversation, perhaps with a view to maybe forging one or two connections that might be useful at some point in the future. Yeah, can't be doing with it. So if AI could somehow come in and do all of that networking for me and just give me a bunch of perfectly formed connections that would suit me in the future, job done.
I believe that's referred to, Lee, as neural networking. Thank you very much. Ryan. Did
you set that one up, Gwilym?
No, I'm just here. I'm here all week.
You're on fire.
So, Ryan, what job that you do would you prefer AI did?
But before I give you an answer, and it's an easy one, Lee, have you guys experimented all with the Google, Notebook LM?
No.
Yeah, well, so take a paper or something and you drop it in a folder, and a Google podcast emerges from this of two kind of emotionally intelligent sounding, human sounding voices debating the subject of this thing. It's basically an automatic podcast generator, and it takes about 2 minutes to make one. But,
perfect.
No one would listen to that and replace you two at this job, I'm sure. Grading papers. I mean, my students use LLMs to write the papers. I should be able to use LLMs to grade the papers. At which point, one kind of wonders about the purpose of the whole system. But anyway, I don't like grading.
Lee, I'll jump in. I know you're going to ask me. My answer.
I was going to come back on the grading thing first because, of course, I used to. I was a teacher in further and higher education, and I always found it easy just to stand at the top of the stairs and lob papers down the stairs. And the further they flew, the heavier they were. So the higher the grade.
Yeah, I mean, well, to be fair, that is more or less what I do. But it would be even easier to just upload it all to an AI and have it put the numbers in, or to simulate the stair experiment.
Yeah, I'm sure we're really infusing your students as we speak. So
no, they're not listening. Don't worry.
Perfect. Yeah, no one does. Gwilym, come on then. What's yours?
I'm going to be festive. Christmas shopping. I do it all online anyway. Just want AI to go and do it. It's just innovating. It's innovating.
Do you find that more and more people are using these blooming online list things for Christmas shopping? We do it now with like Secret Santa at work. Now we do it in our family, where you kind of upload a wish list and someone will buy you a gift. What's the point? What's the point in me telling people things that they can buy me when I can just go and buy them myself?
That's a good point. Although my family approach is that if you ask for something, you can't have it. So you have to ask for something you don't want, and then you won't get it, and you'll get what you might want. It's quite complicated.
Oh, some subtle kind of psychology going on. I've not really thought about that.
It's quite messy.
Well, it sounds better. I'm supposed to guess what people want, and if I guess wrong, I get punished. So I prefer your list versions.
I can't. I don't have enough time in my life to sit down and build an Amazon gift list. It's just not going to happen.
You're the man who has everything anyway. Let's face it.
Well, there you go.
Yeah. All right. Thank you for coming back and gracing the podcast. Always a pleasure to have you on. Gwilym, thank you for just being the consummate co-host as you always are.
Yeah.
And thanks to all of our listeners who are now going to rush off and leave us a little review on the podcasting platform of their choice so that other people can find us. Maybe that's something that AI could do for us. Perhaps we could get some kind of AI crawly bot thing or whatever they're called to crawl all over the podcasting world and leave lots of reviews about 2IPs. Thanks both.
Cheers.
Cheers.